Okay. Welcome to the second talk shop session in our pilot inaugural series. As was the case last time, if you were here, and even if you weren't, this session will last about 60 minutes. It's designed to give us opportunities to have some fellowship and ask some questions with other experts and related professionals in our field about topics that are really important and meaningful to those of us in land offices across Indian country. Today's topic is fee to trust. We had a fairly significant enrollment for this session, so we may have a lot to get through yet, but I want to lay a couple of ground rules out there. That way everyone's on board with what's happening today. So in comparison to our normal webinars, this is much more informal. If you have any questions or comments about fee to trust, the process, procedures, or any component thereof, you can type them in the chat box. That would be fine. But you could also raise your hand, and I will do my best when called upon to ask you to unmute your microphone, and you can communicate directly with us in that format. So that's an important piece of this. And because we only have 60 minutes, please do get your questions, comments going. That way we have a chance to get through them. This is recorded for future reference and will be on the Indian Land Tenure Foundation's Vimeo account shortly. And finally, and perhaps something of some interest to many of you on today's session, is that we have next week on the 13th at 12 Central, our third and final part of the Fee to Trust webinar series, Acceptance and Conveyance and Scenarios and Solutions. So I'm going to put that link in the chat box as soon as I'm done with this this introduction. That way that you can open it at least. It's a direct link. Everyone should be able to register with it, and there shouldn't be any kind of problems with that because it's not going through our emails. Okay, so click on it, enroll. You will be getting emails later this week and next week about that as well. So be aware, please. And as always, if you have any questions or feedback, please do let me know. I know that some of you wish these sessions could be longer. Again, this is a pilot series, so we're trying to better understand how this is going to work. And so thank you for your patience in that. And I look forward to a really engaging session this afternoon. And to start off today, I want to introduce Karen Woodard, she has a great deal of experience in Indian country, fee to trust issues, realty in general. She's on today. Is going to offer some expertise and answer some of your questions. Because there isn't a presentation, we'll be waiting for some of your feedback as we do go through some of these introductions. So I'll start with Karen Woodard, who will introduce herself, and then some of the other board members who are on the call today.
All right, thank you, Nick. Karen Woodard, Realty Administrator for the Morongo Band of Mission Indians. I've been working in realty for 22 years now. Have done approximately 2,200 acres in fee to trust for the tribe, as well as done individual applications and mandatory acquisition. So hopefully I can offer some knowledge today. So I'm going to pass this on to Sarah. Is she on here? Sarah Lawson?
I'm here. Good morning, everybody. My name is Sarah Rubidoux Lawson. I'm an attorney with Schwabe, Williamson & Wyatt in Seattle, Washington. I practice federal Indian law and tribal law, so I deal a lot with Indian lands and everything that has to do with Indian lands, including leases, rights of ways, gift deeds, and of course, fee to trust. So I've done fee to trust actually since it was one of the first transactions I did right when I got out of law school. My boss handed me a fee to trust application and said, here, do this. I was like, what? So I've done discretionary acquisitions, I've done mandatory acquisitions, and I continue to advise tribal clients on fee to trust applications and acquisitions. With that, I will pass it off to the next NTLA board member. Who should that be, Nick?
Let's see. Where did Katie go? Is
Yes.
Katie on?
Katie, Miss Katie Yates free.
Yes.
She's on mute.
May have thrown her a curveball on that one there.
So this is Brenda Tomaras. I'm
Good.
sorry,
Brenda.
I was off on another line, but whatever Sarah said, yes.
Brenda, do you want to introduce yourself?
Okay. Brenda Tomaras. I'm an attorney that works out of California. I'm on the board, been there for, I don't know, a long time. Do a lot of fee trust work, and am excited by these informal casual chats. I'm sure Sarah gave the proviso that none of the stuff that either of us say is actual legal advice, but we will try and help you with as much other stuff as possible.
Yes, so I didn't actually give the proviso, Brenda, but I will reinforce that neither Brenda nor I are your attorneys. Our appearance on this call today does not create a lawyer-client relationship. Nothing that we say here is actually legal advice. But with that, I see Erick Giles is on as well, and Erick is also a board member. Erick, do you want to introduce yourself?
Hi, can you hear me now, Sarah?
Yep.
Well, thank you. My name is Erick Giles. I'm a board member. I'm an attorney here at the Law Office of Drummond Woodson. I work in the Tribal Nations Practice Group, and my specialty is more recently been working in the cannabis brewery distillery space, but I've also just had a history of working on land in the trust applications, Indian land tenure issues, and climate adaptation. So thank you all for coming and attending.
Right. I think that that's all the board members, so I'll kick it back over to Karen or Nick.
Actually, I think we ought to just jump into some questions here, and I'm actually interested in this one as well. It's from Bill Holloway regarding the Carcieri and is it Pachek exceptions that have been appearing on commitments recently. I have not seen those yet. So has anybody seen those on the board? I haven't.
Well, they did. That's what the UFJ determination is. I'm assuming that's what they're saying. I don't know what they mean by an exception.
Yeah, so I'm guessing without seeing the actual title commitment that Bill's referring to, that there's an exception listed on the title commitment that says that perhaps the title company is not ensuring whether the tribe is under federal jurisdiction for purposes of a Carcieri or Pachak analysis, which seems weird. I don't know why a title company would want to put that on a title commitment, or what level of risk they think they have where they feel like they need to put that exception on a title commitment. I would say reach out to the title company and see if they'll remove the title commitment. Bill, I'd be interested to know which title company it is that you are working with who has decided that that needs to be on there. So title companies,
Yeah,
go ahead, Brenda.
no, I was going to say, so sorry, I'm like trying to get my head into the game. I was like thinking of decisions and not title commitments. So yeah, so there's a whole bunch of underwriters that get together that are supposedly the Indian experts. And yeah, most of the title companies, at least out here in California, have some sort of exception like that. Just because they're saying, well, if the US taken the land in illegally, we're not going to cover it, which is a stupid thing. But, they've got a lot of, in fact, if you guys want to go talk about other stuff, I will find one that's got that kind of stuff in it, and I can sort of read off various exceptions. I usually argue them out of it, just tell them that the fact that, you know, a court finds that it was an illegal action doesn't mean that, I mean, the whole thing is null then. And so it doesn't come back on title for any reason. It's not a
Yeah.
title. It's an authority issue. So.
So does
Yeah.
has a solicitor weighed in on any of these, on the title policies?
Yeah, yeah, most of the time they want them taken off.
Mhm. Yeah, that's interesting. I didn't realize that this was maybe coming out of ALTA, and I know a few of the people who are involved with that group in ALTA. So I might have a phone call later.
Yeah, that'd be good.
Knowing at least one of them, the fact that this is appearing does not surprise me. But yeah, I'll just leave it at that.
Well, I know we've seen requests for waivers of sovereign immunity, so I don't know if that's one of them. As well as they're wanting documentation now to prove that our chairman can actually sign documents for the escrow. So we've been running into some really strange things with title as well. I'm not really sure. We've been trying to get a meeting set up with their attorneys and their underwriters, but that hasn't been.
What company are you guys using, Karen?
Lawyers title, which I've never had issues with lawyers title. They've always done a great job for us. And so I'm not sure where this is coming from.
Well,
I
it is
think-
from the, you know, a group of people who think they know what they're doing.
Yeah, they they're not Indian law attorneys, but they slept at the Holiday Inn Express last night. But I've seen a lot of this happen after McGirt. So after the McGirt decision came out about 1.5 years ago, there became a lot more interest in Indian lands and what is included in the Indian lands and what is reservation land versus non-reservation land and trust land and whatever. And I've seen a lot of that come out of interest expressed by the title companies that are trying to ensure transactions that may or may not be within the boundaries of a reservation anymore. So my personal feeling is that it's all coming out of McGirt.
No, I'm going to disagree with you there because I've been seeing them long before McGirt. It really is out of Karcheri and Patchak.
Okay.
So can we have maybe the attorneys talk about the McGirt case?
Yeah, go ahead, go for it, Sarah.
I'm gonna pass that off to Eric because I've been doing all the talking so far.
So McGirt versus Oklahoma, Supreme Court decision that came down last year, and it deals with my tribe, Muskogee Creek Nation, Oklahoma, and whether or not the reservation had been diminished or disestablished. And the holding from the Supreme Court was that there was no act of Congress that expressly disestablished the reservation boundaries of 1866. So a significant portion of eastern Oklahoma, it was always Creek land, Creek reservation, has now been essentially affirmed. And so the reservation boundaries now encompass a majority of the city of Tulsa, and well, a significant number of towns and municipalities. And so that case, it was significant in that it really was, I think, ultimately an attempt by the state of Oklahoma to overturn an existing precedent of Solomon versus Bartlett that said the only Congress can terminate an Indian reservation or just establish an Indian reservation. And what Oklahoma was trying to argue was that, you know, essentially it was just like a come on argument. Like, you know, we've been asserting civil and criminal jurisdiction within the Creek Reservation since statehood, which is about 19 1908 or 09, and we've been doing it for so long. So even though Congress never actually disestablished or terminated the reservation, we have just, we've been superior from the beginning, and we continue to assert our authority. So you should just go along with it and just forget all of these, existing precedents of Indian law, and ignore. Essentially, they wanted the court to ignore, congressional acts, and they lost. And so, what the outcome has been is that now the tribe is in a position of really beginning to assert criminal jurisdiction for those crimes that are considered not major crimes. The major crimes are being now prosecuted in federal courts. The tribe is asserting criminal jurisdiction over those that are not federal crimes. And then now there's an open question about civil and regulatory jurisdiction within the reservation boundaries. Oklahoma has since requested the Supreme Court more recently to either modify McGirt's holding or just overturn it completely. And so it's a continuing issue. The primary argument again on Oklahoma is just that you're disrupting our entire state criminal system of prosecution, and all these prisoners are getting released from jail, and the sky is falling. But really, when you look at the data and all the analysis, none of that is happening. And so it's really just a big, there's going to be having to be a big negotiation between the state and our tribe. Since then, the remaining 5 tribes, their reservations have been affirmed through the Oklahoma criminal appeals courts. So now you have 5 tribes have now reaffirmed their reservation boundaries.
So just to go back, I've got a couple of, I didn't pull my Old Republic, but I've got a First American title. Doesn't specifically refer to Carcieri or Patchak, but the exception is any claim that the United States lacks proper authority to acquire or hold title to the land or arising from or related to an alleged defect in the process of approving or authorizing the acquisition of the title by the United States. So that to me is Carcieri and Patchak.
Mm-hmm.
I've got, I was just looking up at my fidelity too. So, the thing is that what you have to do, and Sarah kind of mentioned that there's typically an underwriter that works for each company that deals with all the Indian land issues. And you need to be able to, sort of find out who that is and call them. I mean, I know a couple of them. And so call them and explain to them, what you need. And a lot of it depends on your solicitor too. So some solicitors may just ignore it and not care about whether it comes off or not.
So I had a question regarding encumbrances, easements in feeder trust applications. Is anyone had an existing easement for conservation purposes? If that's already been in place while the land was held in fee, and then applied for that land to be placed in the trust, and has it been accepted? Has the easement been accepted by the BIA when the land has been processed for accepting it into trust?
Yeah, our solicitors out here in California don't accept that.
Yeah. I did find something about the it's the big Bonneville Power Company in the Northwest, and that they had a report about how they've come to agreements with the solicitors, and that they've negotiated conservation easements, and have placed them on those fee lands before they've sold them to tribes, and then the tribes have processed them into trust. But I'm sure if that was just the exception.
I think it's going to depend on the language of the conservation easement. So I think if the easement itself has language that says that the owner of the underlying property is restricted from doing the following things, or that the owner of the underlying property has an affirmative duty to do certain things, then once the United States becomes that owner of the property, then obviously they're on the hook for doing or not doing whatever it is. But if the conservation easement doesn't contain any duties for the owner of the property, and just says that, the tribe will continue to do, maintenance on the property, or the tribe will continue to have a stand of trees on the property or something like that. So that basically there's nothing that requires the United States to do or not do anything, then I think that conservation easement might be okay. And so the difference there might be that if it's an older conservation easement that was entered on the property when the property was in fee, then it is probably going to have that owner specific responsibility language. But if it's something that the tribe has acquired and they're willing to allow a conservation easement to go over it. So for example, where a tribe is acquiring property from BPA, and we all know that the tribe's going to want to put that property into trust, and BPA wants that conservation easement, we can work out the details of the conservation easement in advance to make sure that there's no restrictions on what the government can do as the property owner.
Yeah. And would another way to go about it though, would just, if we didn't have the conservation easement and then we just brought it into trust, we can do a right-of-way agreement for conservation purposes under those right-of-way regulations.
Yeah, you could probably do a conservation easement as a right-of-way.
Yeah. So.
Under 25 CFR, 25 CFR Part 169 is the citation for the folks on the call here.
That's great. Yeah, I mean, so there's just opportunities where tribes, get these power companies are selling their excess lands, or timber companies that have excess lands that they are interested in conveying to tribes, but there'll be environmental conditions or conservation purposes on those that they have to put on there, and obviously encumbrances or liens on the lands are a problem for bringing those into trust. And so we're just trying to look for ways that would help facilitate that, being able to bring those in without having to get those removed.
You could probably also go back to the holder of the conservation easement and just ask if you can modify the conservation easement in a way that the solicitor would allow the property to then go into trust.
Yeah, as long as it didn't put any liabilities on the US, right? I mean, that's what that's their whole concern. So.
And does everyone record their lands at the county before you place them in, before you apply for putting them in the trust?
Well,
What do you mean before?
yeah,
So if the tribe purchases land, it's from a non-Indian landowner, it's conveyed to the tribe has it in fee. I guess just by the nature of the transaction, it would be recorded at the county.
Right.
But if we had, I don't know if there's a scenario where we have like lands that are already in trust, but they're not recorded at the county. Do we go back and record them with the counties, or we just leave them at the LTRO offices?
is the county trying to tax them at all?
Yes, yep.
Oh, well then, yeah, you need to, you need to record it with the county then.
Right.
I've written so many letters very expressly saying this is Indian country, you know, so.
Yeah, you've got to record the grant deed
Mhm.
going from whoever that seller was to the tribe. That's going to be recorded in the county. And then the notice of conveyance, when it comes out, they have to record that in the county, removing it from the county's tax roll.
Okay.
So that's what that's doing. That removes it from the tax roll. And then it goes to LTRO for their maintenance and issuing the track number and all that.
So it was a notice of conveyance?
Yeah. Yeah. And that's where they changed the grant deed from, you know, that the federally recognized tribe to in United States of America and trust for that federally recognized tribe.
Mm-hmm, mm-hmm.
Yeah. And that should remove it from the tax roll.
Is the notice of conveyance, is that a form, as a federal form, or is it a state?
So it's a federal form that's would come from the region, whoever that regional director is that signs that.
Yeah, and so they should be the ones that, okay.
And they should be recording it on your behalf. And correct me if I'm wrong, Brenda, our consortium still does that, correct? Unless the tribe requests that they don't.
I think that they do. I don't know. My clients usually are so anxious that they just record it themselves.
Yeah. Yeah. Depends on the transaction. Yes. Sometimes, you know, they want to do it on their own.
Mhm. Do you guys participate in a fee to trust consortium? It's made up of like different tribes and different regions with a BIA
Mhm.
kind of officer.
Yeah. So the California consortium started back in 2001. A lot of tribes had applications that weren't being processed. And we didn't have staff at the Bureau that was qualified or had knowledge of how to process a fee to trust transaction. So tribes got together and tried to figure out a way to get these applications moving forward. And that's when they established the consortium, and tribes take a portion of their tribal priority allocation and they give that to the consortium to pay for the staff to work directly on applications.
Mhm, mhm.
So it's worked really well for California.
Okay.
I think we've got about 70 members now and that's Northern, Central, and Southern California.
Looks like we have another comment here in the chat from Riley. Doesn't it also depend on whether the tribe has a 638 realty functions?
Doesn't what depend? The recording part or? No? Okay.
Oh. Who is responsible for?
That would depend probably on what region you're in and not whether or not you're compacted or contracted. You know, despite statements that I've heard recently to the contrary, anyone in this room who's done much fee to trust will probably agree with me when I say that every region does things differently. And so you have sort of local rules as to how the application has to be formatted, what is required to go into the application, as well as who's in charge of doing what. So I'll say that, you know, in the Northwest region, one thing that we have to do is we have to have our land description review and our chain of surveys already signed off by BLM when we submit our fee to trust application. Another thing that has come out more recently in May, So in May, the Northwest region issued a FEDA trust flowchart that assigns certain functions in the FEDA trust process to contracted or compacted tribes. Most of those functions cannot be performed unless you have access to TAMs. So if you don't have access to TAMs, those functions really all still lie with the Bureau of Indian Affairs. If you do have access to TAMs, I would highly suggest that you have a conversation with your agency or your region, because I know that at least in the Northwest region, we are seeing a push from the regional office to push more functions down onto contracted and compacted tribes, based on the idea that, the tribe has taken the money, so they have to do all the things. And yet there are certain functions that are inherent federal functions that can only be performed by BIA, like approvals can only be performed by BIA. Inspections can only be performed by BIA staff. And so BIA will need to be reminded that there are certain inherent federal functions that compacted and contracted tribes cannot perform. So yeah, that's a whole thing there. You'd also want to take a look at your compact. There's this push from the Northwest region. We've heard recently that the Northwest region is reviewing every tribe's compact or contract and is determining what functions the tribes are responsible for and what functions BIA is responsible for. I don't believe that this properly seats any of the tribes' self-determination compacts. If you read the Indian Self-Determination Act, it is very pro-tribal, and there's very specific language in the act and the regulations that states that the tribes decide what functions they perform, BIA does not decide. So they're trying to flip the analysis a little bit, and I know that we're giving some pushback in the Northwest region, but we know that that is going on.
So I'm just going to comment a little bit too on actually who's responsible for recording. Ultimately, the BIA is responsible for recording the notice or the conveyance and the grant deed itself. But as Brenda said, and my department as well, Morongo, prefers that they just send us the grant deeds and then we'll record them and then we'll send them back the recorded document. Only because we want to know that that document isn't going to get lost in the mail or, set aside. It's not going to sit there at the county. So we actually do that ourselves. But we also, because Morongo contracts the LTRO function, we also do the recording of that document in the LTRO, so in the TAMP system. So we kind of follow it through from that, as soon as we get that notice of conveyance all the way to the end to make sure it is issued.
I think you guys are the only compacted LTRO or contracted LTRO in the United States, aren't you, Karen?
No, I think there's 5 of us.
Okay.
And I used to know what that was and I can't remember now. I'm sure if Matt, I think is on he might remember who they are, but he's on here, but yeah, at the top of my head, I can't remember what they were, but yes, we're 1 of 5.
What was the question?
What are the other 5 tribes that contract their LTRO?
Oh, it's more than 5 now. I think it's up to, it's up to like 9 or 10. Colville, Agua, Morongo, Citizen Potawatomi, Flathead.
Yeah.
There's a couple more, but it's more than, it's somewhere in the 10, 11, 12 range now, I think.
It's a good thing.
No, it's a great thing.
Yep. All right, we have any more questions?
Something I might add to that, if some of the participants in today's session would like just to talk more about their experiences going through FEDA Trust. The this can be a therapy session of some sorts. Maybe we could help you to understand some pieces of that, what happened to you. It's certainly a challenge for some people. Oh, we have our first guest. Matt has returned. I'll ask him to unmute.
The question actually I had is, and it's mainly for all the people that are outside of, Karen and I's office. Has anybody heard anything? I know that, Sarah's discussed about the strike force task team, whatever it is in Albuquerque. Has there been any word or discussion from across the country of some of the restrictions and rules kind of being lifted that were, implemented over the last 4 to 5 years and streamlining the process? I know that everybody's going to Albuquerque and all that. Has there been any discussion about it coming back to the regions?
I haven't heard anything.
So in the Northwest region, we heard last week that there's a Feed a Trust strike team that has been created that's in Albuquerque. It's comprised of about 6, I think, realty officers from 6 different regions throughout the United States who have been sent to Albuquerque specifically to address the backlog of Feed a Trust applications. I don't know that I don't know exactly what backlog they're looking at. So I don't know if they're looking at only off-reservation Feed a Trust or on-reservation Feed a Trust. But we do know that this strike team has been created to help address the backlog of applications that are there. I have seen that some off-reservation Feed a Trust applications, when the process changed in May, and when the secretarial orders were issued that said that regions could go back to processing off-reservation Feed a Trust applications. I did see that a few applications that I knew that were pending that were off-reservation were then sent to the region for completion. But I don't know if it's been all of them or maybe a handful of them that were at the end of the process, or what exactly the strike team is looking at.
So no good news. Okay.
Does anyone, so there's I don't know where we are in the questions here, but I see a question from Desiree Michael that asked about the California Feed a Trust Consortium. The folks who are part of that consortium, is there like a organizational document or charter document for the tribes that have all signed on to it? How is that? Can you tell us how that's organized?
Yeah, so there's an MOU entered into between the tribes and the BIA, and then what happens is tribes issue resolutions transferring part of their TPA funds over to the BIA. So ours, I believe, so there is a consortium in the Midwest as well, but I believe it operates differently from ours. Ours was sort of the first one. And I'm not sure how the Midwest one operates, but I believe that it's very different, because there was points in time where the administration wanted to try and get everybody sort of on the same page with respect to all of those. Do you know more about that, Karen?
No, unfortunately, no, I don't. I don't know any more about that.
Yeah, so I would go to your regional director first, and broach the subject to see whether he or she is interested in assisting you guys in putting together something like that. Because our regional, that we got it done was our regional director really pushed for it for us.
Yeah, you definitely have to have the regional director's support. That's for sure. In fact, I think our regional director was actually the one that came up with some of these ideas.
Yeah, I think so.
We have a Thurman Loretto. Wanted to talk about some problems that they're facing. Can they unmute themselves and kind of talk about what it is they're experiencing?
Good afternoon. Can everybody hear me?
Yes.
All right. Yeah, my name's Thurman Loretto. I'm sitting here with my assistant, my realty assistant, Desiree Lucero. We're from the Pueblo of Jemez in New Mexico. We currently purchased 23 acres north of reservation in the village of Jemez Springs. And there's quite a bit going on there. You know, it was an old location. They sold it to the Pueblo. Now we're getting a lot of, I guess, blowback from Jemez Springs and about, you know, putting it into trust. So we did get all the application and everything in place, but we did get a letter back from them stating that they are, of course, against it. They have some easements within the property, right-of-ways on ditches. We got a couple of electric lines that we need applications done on. And they also have an old cell tower easement that runs on the south or on the west side of the property that, you know, BIA is wanting us to, you know, have them relinquish that because they don't really actually have a legit lease or anything in file with counties. You guys were talking about county records and stuff. So we're having that problem right now. We're going on, I believe 3 years now. I'm trying to get this thing approved. We're just at that point to where, you know, we just, I guess not really knowing how much forward to push this. We've been working with our attorneys on this, and, you know, it's getting to a point to where it's getting really into some sensitive issues here. I guess that's what I want to talk about is how would you guys, you know, recommend the Pueblo moving forward with this? We have 638, our realty here to the Pueblo. Also, you know, just to let you guys know, we were just recently approved within the last month or so with the Heart Act here at the Pueblo. So we're a Heart Act tribe now too as well. But yeah, I would like some input from anybody out there to see how we can move forward with this.
So, I'm kind of curious about you said Jimenez Springs community?
Yeah, Jemez Springs.
Yeah, is that a tribal community?
No, it's not.
And the property is in fee.
Yes, it's in fee right now, currently.
So
And that's one thing they have told us directly, that they don't want to lose that state tax that we pay on that because that helps the community as well too. So, you know, first thing that they were worried about is that, okay, well, if you take this over, you guys put in a casino in the middle of the town, and, you know, that's not the plan for the Pueblo.
So I'm gonna guess that this is like one of the first feet of trust you guys have done, right?
We did one, but it was only for 5 acres out. I think it's about 75 miles east of here in Pecos, Pueblo, Pecos, New Mexico. But that had nothing to do with anything within there. It was just lands that were
Right.
being sold to the Pueblo.
Yeah, these are like very typical complaints and assertions by the local communities. Anytime any tribe wants to take land into trust, you know, usually the BI, I mean, as long as you've got your sufficient, you know, purpose and, you know, need for land, et cetera, you know, all of their allegations shouldn't be impacting how BIA decides your application.
Okay.
Some tribes in California have gone through and, you know, tried to sort of meet with communities and to get support, you know, work with them. Sometimes that works, but, and I apologize because I missed part of it. Were you saying that part of it had to do with easements that they have?
They have a couple of irrigation ditches that start with on the public, on the fee simple lands right now, the ones that the property that we purchased. So they have a couple of irrigation ditches there. Also a couple of hiking trail, or well, one hiking trail, which used to be an old cell tower site. Yeah, and that cell tower site is no longer in use. There's still a pole up there for in case they need to connect electricity to it, but now they're stating that, you know, they want to reserve the right to use that still in the future in case they need to set up anything for emergency response use. The canyon up there is it's pretty sparse with cell phone coverage and whatnot. So that's a pretty prime area, but that's been decommissioned for years now, over 20 years, I believe.
And is that recorded on title now?
That they have a map on it, but we don't find nothing that's been recorded
Okay, so nothing on
on
title.
account. No.
Yeah, so and I'm assuming the Pueblo does, you know, it sounds for sure like they don't want to continue the access to the cell tower site, but what about the irrigation ditch? Are you guys trying to, you know, basically do away with the irrigation ditch? Or are you willing to let them have an easement for that?
Yeah, we've met with the mayor of Jemez Springs and his council, our governors, and also our tribal administrators, and we've all sat down with them, and you know, we've explained to them that we're not trying to cut them off or whatnot from everything. We're willing to make or put together some type of MOU with their mayordomos so they can get in and access the ditches, because that is their, I mean, see, because the tribe is also in a water rights case with the villages up north from here and down south, so it's a pretty sticky situation.
So have you submitted an application yet?
Yes, we have, but we still got to get these things taken care of before they can move it forward. It's what we understand from our regional director, Patricia Mattingly.
Have they sent you a letter, the regional administrator, listing out the issues that they have?
Yes. Yes.
Interesting. I'm surprised that the Bureau is taking such a stance on this.
Yeah.
You know, I don't understand that. I mean,
That's what our attorneys as well, they're also arguing that with the solicitor's office and whatnot down here too as well, why this is their letter and whatnot's making a bigger impact on our application, because this application has been on file pending for about 3-4 years now.
And is this discretionary or a mandatory? Like, does a mandatory trust acquisition is that the Secretary of Interior has to take this land into trust, and there's usually some federal law that says it would apply specifically to Jemez and say lands within this service area that are applied for to be brought in trust, they shall be accepted into trust. And so that's a mandatory acquisition. Some of these other ones that we're talking about are discretionary acquisitions where the secretary doesn't have to. So I'd be interested to know if it was a mandatory acquisition, because in that case, there really isn't a lot of space for, I mean, the BIA can make stuff up and try and jam up things during the review process, but ultimately they have to take that land into trust if it's a mandatory acquisition.
Yeah, honestly, that's the first I've heard of it. We've talked about it, but it hasn't really been discussed with BIA as far as if it's mandatory or discretionary. As the way the public sees it, yeah, it is. We're taking it as a mandatory fee to trust application.
And I'm betting that it's probably, unless there's some statutory authority, I don't think that you would be having this issue with the solicitors and with the BIA if it was a mandatory acquisition. So I'm betting it's a discretionary acquisition and they're just gun shy because they basically sort of believe that they'll be sued if they take the discretionary action of taking this land into trust. But I'm wondering if the tribe could talk with the solicitors and, I mean, I'm wondering, the way that we would solve this outside Indian country is we would just give them an indemnification agreement. Like, okay, if you get sued, we'll pay for your legal costs.
Well,
But go ahead, Brenda.
I was gonna say, well, I would take it up to the next level. I would try and get to the ASIA.
Mhm.
I mean, certainly the indemnification has been done in the past, but supposedly this administration is pro fee to trust, and the things you're talking about do not sound to me like they're anything really unusual or crucial, it's like significant that's holding this up. And so it sounds to me like it's your region for
Mhm.
whatever reason.
Mhm.
And I would talk to your attorneys about taking it up to the, central office, call ASIA or somebody and see what the heck is going on.
Mhm.
I mean,
Yeah, we have talked about that as well with our attorneys, so we're at that point right now to see because it's just taking way too long to get this thing done, and a lot of money.
What's the longest anyone's had a fee to trust application take?
we had one that was 12 years.
Even imagine. I've never had one take more than 2 years.
Yeah, we had a mandatory trust acquisition take 2 years.
Mandatory.
Yeah, that was a mandatory one.
Wow.
So,
So, it's 3, and Thurman, you said you've been waiting for 3 years now?
I think we're going on 4 now, yeah.
Okay.
Yeah.
some do take longer than others, but yeah, I think
Yeah.
everybody's, you need to take it up to a higher level
Mhm.
to get some answers.
And after that, if you don't get if a decision does come down, I think you always want to preserve all the records and correspondences so that you can take that up to the, what was it, the IBIA, Indian Board of Indian Appeals.
Yeah. Yeah, I mean, that's another option is if you're not getting, I mean, it probably wouldn't do you any good because you are having communications with BIA, but there is, at least there used to be, and I don't know what the code section is, maybe Sarah or Eric knows, but there's one about, BIA being inactive and not taking action on a request that you can take to IBIA. The problem is, those rarely do a little good because once you take that there, then the BIA does something so that they can say they're not being inactive. So,
but I'm curious though, like again, like this is those easements that are there. And this goes back to the question at the beginning is the irrigation channels and everything. I mean, that's conveying, that's water for the city of Jemez Springs. Would the BIA take land in the trust with that condition on there? Because water rights is a huge issue in this region, and so I don't know if there was. We're speculating, but that to me would sound like we would want to have all those encumbrances removed, before they would take that into trust.
Interesting.
Yeah, I don't think BIA did really have a problem with that, as long as they had said, as long as we put something in place and put it in the application that we did have some type of MOU with the city of Jemez Springs, then it would be okay to move that forward. It's just that easement for the cell tower that they wanted us to have them relinquish quitclaim the easement back to the tribe so they can take it off, because it was mostly because of a trespass issue. They didn't want that coming up, in the future, but
Mhm.
Amos Springs doesn't want to relinquish their right to that easement because they use it as a public hiking trail right now.
Oh,
But if it's not recorded on title, it's not a true easement.
right.
Yeah, and that's where our fight is now with our attorneys with the city of Amos Springs to get that taken care of. But
Interesting.
thank you guys. I appreciate your input. We will look into it more.
Chairman.
Keep us posted on how you do.
Yeah.
Yeah, we'll do.
It looks like we're almost into our hour.
I know these sessions really do go pretty quickly. There's one more question in chat from Willa Paulus. Is the Northwest Region FEDA Trust process flowchart discussed available online?
I haven't seen it posted anywhere. It was just emailed out to the tribes in the Northwest region. So I guess if you registered for the chat, then Nichlas probably has your email address, Willa. And so I can just send it to Nick and have Nick send it on, or have Nick send me your email address and I'll send it to you.
Yeah, we'll make sure you get it there, Willa. I know I did see a flow chart recently that Sarah sent me on FEDA Trust process, and the steps. The steps are out there, right? But when you see it in a flow chart, like, what is going on? What are we doing here? And that's when I remember that I have some philosophical disagreements with this whole process. But that's why we're here too. Oh, and you're very welcome. All right. Well, we're at our time. So we're going to close this session out, but I have to say, it's so pleasing to have the questions and comments and discussion that we did have in this session. Many thanks to Karen, Eric, Sarah, and Brenda for their very significant contributions to this hour's piece. Going forward, let's see if I can still have it here. Nope, that's not it. This afternoon, actually, you're going to get the email about FEDA Trust webinar for next week. I did get one email saying that it registered her for September session, which I thought was really strange, but because it did work for a number of others who did register. So, hopefully when the email comes out, you could register for the October webinar, and it's going to be okay, and we'll see you then next week. So anyway, we'll talk to you all soon. Certainly have a good rest of your day, and until next time.
Thank you, everyone.